In today's class, we will discuss about administration of justice in ancient India. As you all know, administration of justice is a vital aspect of government protection. The judicial administration in ancient India was based upon the basic theme that the subsistence of the state is justified by maintaining dharma and disbursing justice to its people. Precisely, we can say that the ancient Indian judicial system intended to ensure impartial justice to everyone. Under Hindu law, it was considered to be the most important duty of the king. King was required to protect his subjects under all circumstances. At the same time, he was also expected to guarantee the just resolution of their disputes. He was in fact the supreme judge of his domain. Talking about Rajadharma, Rajadharma is said to be the quintessence of all dharmas. Rajadharma constituted mainly the duties of the king towards his subjects and other administrative responsibilities. The fundamental function of Rajadharma was to uphold the truth and guarantee the happiness of the people by ensuring social order. The king had to ensure that the people in his kingdom acted according to the rules laid down in the Smritis, the law books of that time. The rights and duties prescribed for the people were based upon the Varnashram system. So, the king was expected to administer justice judiciously and intervene whenever his assistance was required for by a parishad. Now, what is this parishad? This parishad was an assembly of learned men in enforcing the prashad, that is penance, prescribed for various lapses. In ancient Indian thought and philosophy, Rajadharma was considered to be the highest goal of the entire world. It comprehended within itself all the rules of administration of justice, that is akar, vyavhar, and prashad, that is penance. Rajadharma refers to a body of principles that ensures the safety of the subjects of the state by displacing Matsanyay, that is the law of jungle, with the system of equal and just law. And it was put forwarded that the king should derive his satisfaction in the happiness of his subjects. He should consider the welfare of his subjects as his own and keep it as a topmost priority. When we look into the text, we find that not only Dharma Shastras but all the existing texts discuss about king's rights and special privileges. However, the responsibilities and duties of the kings have been greatly emphasized upon. They say that the king cannot do as he please. He has to carry out the dictates of dharma. His power to make rules is limited. If he does not act according to the tenets of dharma, he may be deposed, disobeyed, or killed. There is a story of legendary king Maruta in Markandeya Puran, which depicts how he got warning from his grandmother that king's life is not meant for pleasure and enjoyment. He is expected to take pains for protecting his people and carrying out his duties. In Artha Shastra, Kautilya proclaims the magnificent ideal that in the happiness of the subjects lies the happiness of the king. In their welfare lies his welfare. The good of king does not consist in what is pleasing to him, but what is pleasing to the subjects constitutes his good. Impartial judicial administration brought him the same spiritual reward as Vedic sacrifices. Kings failing in their duty suffered in hell. Even delay in administration of justice was visited with dire penalties. For a legendary king Riga was reborn as a lizard because he kept two litigants waiting in a dispute over a cow. Some sources declared that it was incumbent upon a king to restore the full value of stolen articles to the plaintiff if the thief could not be brought to justice. Moreover, the king was believed to incur the demerit of criminals not brought to book and suffer in the next life accordingly. However, from the secular point of view, the king who perverted justice or was negligent in its administration was in danger of losing his throne. Talking about Vedic period, we don't have any clear evidence about the presence of judicial organizations during Vedic period. Apparently, village elders, they served as judges and punishments were determined based on the nature of the offence. Local uses and customs were taken into consideration while administering justice. There were organizations like Sabha and Samiti. Sabha performed judicial functions as well. Law was both legal and moral. Amongst the various crimes mentioned in the Smritis and other literary works, stya or the theft was the commonest. The Rig Veda often mentions about the thieves or stya or tayu and robbers, taskara, in several hymns. Precisely, we can say that justice as a distinct branch of government was in its inception. Now, talking about the later Vedic period. In the later Vedic period, the two councils, namely Sabha and Samiti, they gradually lost their importance. Now, the real sovereign of the country was Dharma. The king was expected to act according to it. In small kingdoms to which the early Dharma Sutras refer, the king was the sole source of justice. However, in general, the administration of justice was delegated. The king's court was reserved for appeals and serious crimes against the state. Prior to the constitution of the regular courts, which probably took place during modern period around 4th century BC, trials were held in open courts. The king presided over these courts as the chief judge, and in this process he was assisted by assessors who were well versed in scriptures. As far as the composition of the courts was concerned, it varied with time and place. There are evidences that indicates that ancient Indians preferred a bench of magistrates to a single judge. A Jatak story tells of a bench of 5 magistrates. Kautilya advises the king to establish a court with the bench of 3 magistrates for every 10 villages, with higher courts in the districts and provinces. Manu suggests a bench composed of the Pradvivaka, that is chief judge, and 3 other judges. The court presided over by the king was the Supreme Court of Appeal. Every case was examined thoroughly. Ordeals, oaths, and punishments were used as a means for the witness who resorted to false statements for arriving at the truth. It was important for the judges to take into consideration the nature of the crime, the motive of the accused, and his social standing while deciding the cases. The gravity of the offence decided the punishments to be inflicted upon the culprits. During Mauryan period, Kautilya mentions about the existence of 2 types of courts, namely Dharmasthya, which was the civil court, and Kantak Sodhan, which was the criminal court. The civil courts dealt with disputes involving contracts, trespass, inheritance, labor, marriages, dowry, deposits, and interests. According to Kautilya, the criminal courts took cognizance of the cases like protection of artisans, merchants, etc., post-mortem examinations, punishments for mutilation, capital punishment, miscellaneous offences. The literary sources of the Mauryan period, Megasthenes Indica and Kautilya's Arthashastra, describe that the penal code was severe. The punishments like mutilation of limbs and death penalty were in practice. According to Arthashastra, the state recognized the local uses, customs of the people, caste, community, clan and family, every bylaw of the corporate bodies, guilds and organized non-political communities. Kul courts, Kula or Kul courts as mentioned by Mitakshara were the popular courts existing in ancient period. It was basically a group of family elders trying to resolve a dispute. When the method of family arbitration failed, the matter was generally taken to the Shrenis. Now, the term Shreni was used to denote the court of guilds. In all the important towns, there were guild courts embracing all trades, industries, art and craft. The artisans, craftsmen and merchants, they formed their own corporations for the purpose of economic activity for gaining wealth by pursuing their own profession. Now, these guilds have their own rules and regulations which were binding on its members. The Dharma Shastras recognized the validity of the laws and customs established by the guilds. Now, these guild courts, they function as courts to settle disputes amongst their members according to the laws of their profession. The laws of the guilds were upheld by the king and his government. The state, though recognized the judicial rights of the guilds over its members, it did not disregard its duties towards them as its citizens. The guilds were not allowed to exercise their powers like autocrats. Ultimately, they were responsible to the state. Then there were Puga, which was a collaboration of persons drawn from various castes. Now, these persons followed different professions belong to the same town or village. The Sabha of the Vedic period and Gram Vriddha court of Arthashastra are the forerunners of Puga. Then there were other units of administration of justice at the village level, popularly known as village panchayats, which were also invested with judicial powers. Kautilya mentions in Arthashastra that the village court was presided over by the Grama Vriddha. Now, these popular courts settled disputes amongst the village people. It's important to note that although they were essentially non-official and popular, they were also backed and supported by the royal authority. Yajnavalkya, an eminent jurist, elaborates that these village courts were sanctioned by the king. During the reign of Guptas, Swayam, a celebrated Chinese pilgrim, visited India. The age of Guptas, according to him, was a golden age. People were prosperous and happy. The king in his administration used no corporal punishments and criminals were merely fined, keeping in view the severity of the offences. As compared to Mauryas, the penal code of the Guptas was mild. For violating the laws of the state, collection of fine was considered to be the adequate punishment. Later on, even during the time period of Harshvardhan, after Guptas, king continued to be the fountainhead of all the powers. Hunseng, who visited India during the time period of King Harshvardhan, he observed that the imprisonment was the most usual form of punishment existing at that time. Those who were imprisoned were made to work on roads and in public places. Now, this had a deterrent effect on others. Mutilation of limbs was also resorted to as punishments, in which the hands of those indulging in theft were chopped off. Banishment was another type of punishment which was inflicted usually on privileged classes. For murderers, traitors, dacoits and persons guilty of heinous sex crimes, death penalty was the only punishment. The proceeding of the judicial procedure consisted of four main stages. First, Purva Paksha, that is plaintiff first filed a plaint before the registration officer containing particulars of the claim, the year and the place, the nature of the offence, etc. Second, the Uttar Paksha, that is defendant, was served with a notice and was asked by the judge to submit his reply, that is the Uttar. The Dharma Shastras require that in urgent and important cases, the defendant was expected to file his reply immediately. Adjournment ranged from 1 day to 1 year or more. However, Katyayana doesn't favor adjournment. He was of the view that it would further hamper the normal course of judicial procedure and creates complications. However, this facility is denied to the plaintiff. To quote Kautilya here, if the plaintiff to whom a reply has been given by the defendant doesn't counter reply on the same day, he shall lose the suit. For it is the plaintiff who has decided beforehand what is to be done, not the defendant. As far as the defendant's reply was concerned, he was required to meet all the points raised in the plaint. It should be clear, precise, and should be free from absurdity and ambiguity. Third, the trial of the case began with the submission of reply by the defendant. It was now left to the judge, who had heard both the plaintiff and the defendant, to determine on which of the party lies the responsibility of adducing the burden of proof. Modes of proof were of two types, human and divine. Human evidence was of three types again: documents, possession, and witness. Divine proof consisted of ordeals. Ordeals were resorted to only when the ordinary method of proof was not feasible. The Hindu jurists did not give any scope for ambiguity in respect of human proof. They have defined what is a valid document, have classified them, and brought out their utmost utility. They were also aware of spurious documents and have not only severely criticized this practice, but have also prescribed punishment for such offences. The concluding stage of the judicial procedure was the verdict or the nirnay. The king or the chief judge was expected to weigh carefully the evidence produced before the court. After seeking the interpretation of law by those versed in law, had to decide on the success or the defeat of the plaintiff. The verdict was to be pronounced after the judicial assembly arrived at a unanimous decision. The document of victory, that was known as Jayapatra, was given to the party which won the suit. A Jayapatra contained the summary of the plaint, the reply, the evidence, and the decision. It was to bear the royal seal, which was signed by Pradvevaka and other members of the tribunal. The Jayapatra had to be preserved safely so that whenever necessary it would be produced or referred to. Here it is worth mentioning that if law under Kautilya was harsh in the case of lawbreakers, it was equally uncompromising in the case of those who administered it. Judicial corruption is often referred to in the text. The standards set for judges and magistrates were very high. They were expected to be learned, religious, devoid of anger, and as impartial as humanly possible. To prevent bribery, it was suggested that no private interviews should be allowed between the judges and the litigants until the case is settled. Kautilya was for testing the loyalty of the judges periodically by secret agents. Vishnu Smriti, on the other hand, prescribes banishment and forfeiture of all property for a judge found guilty of corruption or injustice. The lawgiver suggested necessary measures to control judiciary by bringing it within the ambit of rule of law. Witnesses also play a significant role in the administration of justice. A witness is the one who has himself seen or heard or experienced the matter in dispute. False witnesses were generally looked upon with great abhorrence. In serious criminal cases, evidence might be accepted from all over the sources. However, in civil law, only certain witnesses were qualified. Generally, women, learned brahmanas, government servants, minors, debtors, persons with criminal records, and persons suffering from physical defects were not considered appropriate for evidence. The evidence of the lower caste people was not valid against the persons of higher caste. Several tests were laid down to assess the veracity of the witness. In ancient India, the administration of justice was uniquely characterized by the use of secret agents appointed to get to the facts of the case. In case there were no witness, the special police officers found out the innocence or the guilt of the persons without any trial. There is no provision in ancient legal literature for the cross-examination of the witness. The espionage system or the secret agents was one of the distinguishing features of the ancient judicial system. When in the ordinary courts, the detection of crime became difficult, the help of the intelligence system was sought. H.V. Srinivas Murthy mentions in his book History of India that the idea of journal espionage is not to molest or harass the people in general, but through it the solidarity and stability of the state can be cemented with an amalgamation of public affection and contentment. It not only served as a mechanism to guard the interests of law and order, but also the people concerned. There were many Brahmins who were learned in law, however, they never constituted a class of professional pleaders. Those who did not serve on the bench presumably used their knowledge to settle the cases out of the court. By the end of this particular period, a class of lawyers in the modern sense was beginning to develop. It is evident from some later texts which allow the litigants to employ proxies who were to be rewarded with share of money involved. P.V. Cain, in his book History of the Dharam Shastras, mentions that the procedures laid down in various texts are complex and that would have certainly required lawyers. Another significant aspect of judicial administration was crime and punishment, which has been discussed at length by the Smritikars. Varna considerations dominated in Manu while prescribing punishments. Manu prescribes admonition, reproof, a fine, corporal punishment and banishment. Kautilya is comparatively rational. He recommends capital punishment for the Brahmanas as well, if he is guilty of high treason. Kautilya, however, treats lower castes with leniency. The criminal code in the Artha Shastra is rather severe. It has been characterized as an eye for an eye and a tooth for a tooth. The tongue of a person who insulted his father, mother, son, brother, teacher or an ascetic was severed. Ashoka dispersed justice with kindness by introducing many reforms in judicial administration and procedure. He enjoined on the Mahamatras and the officials appointed for dispersing justice at the city level to cause less imprisonment and harassment to the people residing in towns. Judicial torture was also used to extort confessions. In context of civil matters, Manu has focused in detail and had made significant observations on debt, property, inheritance and agreements, etc. In context of policy regarding punishments, we find that it was much more advanced, especially in the categories of civil and criminal offences. After discussing all the important aspects of the judicial administration in ancient India, we get to know that ancient Indians had high sense of justice. Although we cannot deny the fact that punishments were based upon caste considerations as put forwarded by Manu and Gautama, however, an endeavour has been made in the present times by focusing more on human dignity. An effort has also been made to compensate by eliminating the humiliation people suffered under the traditional social system of caste and patriarchy. In contemporary Indian society, the realization of both formal and substantive equality under the rule of law provides the opportunity for more creative flourishing of dharma or righteous conduct of the individual and the society. That's all for today. Thank you so much. See you in the next class. Have a good day.